Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, Illinois, I'm finally getting around. I understand I am late to the party, but I am going to get around to getting through all 168 pages of the ruling in Harrel v. Raoul, a successful challenge to the Protect Illinois Communities Act, or as we know, an assault weapon ban and a magazine ban. I've had a chance to, like I say, weed through 168 pages. I think I pulled out some good little nuggets that are worth geeking out about. So let's get you educated about what the court ordered and what the court ruled, and then let's also get you educated about what this means, if anything, to you right now. So today, let's spend a few minutes and let's talk about how Illinois' assault weapon ban got struck down.
Therein lies why we say in the legal defense sector that we are the most value-centered, cost-effective legal defense in the space, and we are. There's no question. Now, again, I've said before, we've got great competitors out there. They have outstanding products. We admire them. They pave the way for us. You know, we analyze the folks out there that are doing the same thing we're doing, and we took some great ideas from them, and we went down a path of believing that we were going to do it with a service aspect, a servant's heart, and we have again. Our number one goal has been to serve others first in a way that the industry hasn't seen.
Right to bear, that's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, Illinois, here's what we're talking about. We're talking about the successful challenge to the Protect Illinois Communities Act, which, by the way, we and many other people had predicted was going to go this way, because let us remember that the judge had previously enjoined the law, so he obviously was no fan of it. Now, I know a lot of people got online last week and clickbaited the living hell out of you with, woohoo, look at this, it's been struck down. We all knew it was going to be struck down. What we were wondering was, would there actually be a window of time? It had been as brief as it may have been, where some of you may have been able to thread a bunch of needles and, add to your collection. Well, no, the big bummer from the whole thing, because again, like I said, the ruling itself was expected. The big bummer was the fact that Judgement Glen just decided to put a 30-day stay in right away, which means nobody had any chance of threading any needles. And of course, then the state of Illinois appealed immediately. Now, to Judgement Glen, if you believe this law to be unconstitutional, violating the Second Amendment through the 14th Amendment, and we know it's a relatively new law, so why would you put a stay on that injunction? I mean, if this law is so offensive to the constitutional rights of Illinois residents, one would think that we just want to cease it right now. Now, I understand if it's a law that, let's say, has been kicking around the state of Illinois for the last 50 years or something. I understand the desire maybe not to instantly enjoin that law, but we're talking about a law that was passed just last year, okay? So that's the big disappointment and why we gave a very measured message. Now, to the other thing to Judgement Glen, this is an exhausting, and I mean absolutely exhausting opinion to read. Well done, but 168 pages, it reads like a history book. What I've done is I have pulled out some pages from the opinion, and I'm just going to try to get you educated. And the first thing I want you to educate you is that Judgement Glen definitely has a little bit of a sense of humor and was definitely setting up where he was going with this when he authored, why are there small lifeboats on gigantic steel ocean liners? Why do we spend thousands equipping our vehicles with airbags? Why do we wear seatbelts and place our infants in safety seats? Why do we build storm shelters under our home? Why do we install ground fault interrupter outlets by sinks and bathtubs? Why do we get painful inoculations? Why do we voluntarily undergo sickening chemotherapy? And why do we protect ourselves with firearms? Now, We know that there is a Seventh Circuit sitting above Judgement Glen that has ruled completely contrary and said, hey, listen, the Second Amendment doesn't even apply to this, right? How is the lower court going to deal with that? Like this. The Seventh Circuit's contrived non-militaristic limitation on the arms protected by the Second Amendment seems unmoored from both text and history. Moreover, even in its own terms, the Seventh Circuit's application of its definition is nonsensical. No army in the world uses a service rifle that is only semi-automatic. And as to the ultimate ruling from the Seventh Circuit, it is difficult to see how the Seventh Circuit could have concluded that the most widely owned semi-automatic rifles are not arms protected by the Second Amendment. Now, some of you may recall the case of Friedman versus City of Highland Park, another assault weapon ban case in which a petition was actually rejected. Judgement Glen points out, though, what a couple justices said when that petition was not accepted, including Justice Thomas. We excluded from protection only those weapons not typically possessed by law-abiding citizens for lawful purposes. And we stress that the very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. And so it is not for any court to determine what is actually appropriate for self-defense. And as the judge writes here, the Bevis Court stated that the military use test employed in Friedman is consonant with Bruin, even though Bruin held that any two-step test is one step too many. So in trying to determine what types of firearms are dangerous and therefore could be banned, Judgement Glen comes up with his own definition. It's a unique one, and it states the following. Therefore, this court defines dangerous as bearable arms that a typical operator cannot reasonably control to neutralize discrete identified aggressors. Once more, it is the lack of the ability to discriminately control the arm and its discharge projectiles that make it dangerous, not its rate of fire. Okay, so Judgement Glen has carved out his own definition for what is dangerous. What is unusual then? Well, Judgement Glen states, therefore, considering the above, unusual is defined as an arm deploying an atypical method to neutralize an opponent in confrontation or that deploys a neutralizing agent that is caustic, incendiary, noxious, poisonous, or radioactive. Unusual would also include those weapons that are not designed for successful self-defense in neutralizing an opponent, but rather are primarily deployed to inflict cruel, brutal, or inhumane suffering on a person. Okay, not a big fan of lower courts coming up with all sorts of new definitions, because that's how we end up with things like in common use for self-defense and things like that. How does the judge tie these two definitions together? He ties them together as, therefore, in relation to the weapons banned by PICA, this court defines common use as presumptively encompassing any bearable rifle, shotgun, or pistol that is capable of semi-automatic fire and is or has been available for purchase, possession, and usage by law-abiding citizens for self-defense, provided that it is not otherwise dangerous and unusual. Okay, that is actually a pretty solid definition, but there's more. Moreover, for the sake of clarity, the court will also include essential features like magazines and non-essential features that increase operability, accuracy, or safety, like the various attachments prohibited by PICA as items that are presumptively in common use. Okay, now we're getting somewhere. But of course, we need to ban these weapons of war because they're being used to slaughter people, right? And that's the sole reason, Judge, by which the state of Illinois should be allowed to do this, because they know what's better for all of us. How did the court deal with that? Pleading for mercy because one is innocent, unarmed, or underarmed is sadly too often a losing strategy in confrontation, especially when the confrontation is catalyzed by evil, hatred, or psychosis. Disarming law-abiding citizens does not also bring about happy endings. Disarming law-abiding citizens does not inoculate us from the evil, hatred, and psychosis or from the tyranny of others. To limit civilians' choice of arms would tip the scale in favor of the aggressors who already will likely have the various tactical advantages, including the element of surprise. All right, and then of course, one of the things that all of those that are proposing flat out bans is saying, listen, when we're talking about in common use, it's not the numerical value. It's a much deeper thought process and equation than that. Of course, that is because they don't want to deal with the numbers because numerical values always favor us. The court was aware of this and dealt with it this way. While this court is cognizant of Beavis's warnings that sales numbers alone are not sufficient to prove that an item is in common use, the court is skeptical of the government's argument that rigid statistical evidence is not only useful, but required to prove that specific weapons, magazines, and attachments are in common use. Okay, now that's in response to a report that was published by NSSF that claimed to prove that magazines holding more than 10 rounds are in common use, which, again, I get it. Why do you have to prove something that we all know? It's literally like having to prove that the sun sets in the west. I get it. But we're talking about what happens when we apply the rules of evidence to it, okay? That report got shredded, however, by the Illinois Attorney Generals. And I mean shredded. And we may do a follow-up video on that. We're going to go ahead and link up their motion to strike that report so you can see what they are claiming, okay? What they are claiming. But the court was like, hey, listen, you're basically asking me to ignore something that is just commonly proven and even acknowledged by your experts and also by Justice Sotomayor in a dissenting opinion. The court is also not convinced that weapons like the AR-15 and its relatives are dangerous and unusual. Considering the court's definition of dangerous, it is clear that a semi-automatic rifle does not suffer from the lack of control as is inherent to machine guns and sawed-off shotguns. Now again, talking about that NSSF report, which has raised some eyebrows in our community, the court put it this way. Thus, even discounting the English survey and those conducted by the NSSF because of the government's identified methodological concerns, it is clearly apparent to this court that law-abiding citizens choose semi-automatic AR and AK-type rifles, semi-automatic shotguns, and various machine pistols, large-capacity magazines, and assorted firearm attachments for self-defense. Okay, so is he enjoining all portions of PICA? No, he still has a beef with the 50 BMG, as follows. That being said, this court is not convinced that any law-abiding citizen would keep a 50 caliber sniper rifle at home for self-defense purposes. Such a weapon is clearly unsuited for self-defense and is properly banned for civilian use by PICA. The same is true for the ammunition it fires. This court also holds that outside of the 50 caliber rifles and ammunition, 50 caliber pistols and any belt-fed weapons have no lawful self-defense purpose. Okay, not a clean sweep, but we are moving in the right direction. Magazines and accessories. Yeah, because you even had to register some of those, right? Okay, what did the court find in relation to that? Regarding 30-round large capacity magazines and the various attachments, pistol grips, flash suppressors, and the like at issue here, this court holds that these devices are also in common use and have legitimate self-defense purposes. For magazines, every round matters in a self-defense scenario. Reloading takes away significant time during which the defender can be injured or wounded. Moreover, unlike in military combat where soldiers are equipped with pockets, vests, and belts to carry spare ammunition, a defender will only have what he or she can carry. Thus, in a critical self-defense scenario, more rounds equals a higher chance of survival. As for the attachments, similarly, the attachments at issue make a weapon safer, easier to aim, and easier to fire, features that are well suited for self-defense. This is especially relevant to an individual who is infirm, small-statured, or has limited firearms training. In a self-defense scenario, every second matters, and this court will not fault individuals who are not able-bodied for choosing weapons that enable them to more carefully defend themselves and their families. Okay, in addition to the bad news about the 50 BMG, Judgement Glen not going to strike down the ban on grenade launchers. Apparently he does not believe that they have any lawful purposes. And then finally, of course, the court has to deal with, but these are all more appropriate for military use. That's the whole reason the Seventh Circuit said that, hey, Second Amendment doesn't even apply there, right? Okay, how did the trial court deal with that? Well, he started this way. Setting emotional reactions aside, comparing an AR-15 to an M16 is like comparing a military-grade Humvee to the Hummer H3 released to the civilian population. Its resemblance to the military version is not a coincidence. It is a feature marketed to appeal to the average law-abiding consumer of such products. So the court then comes up with its own definition of what is a military use weapon. I'm not joking, he actually did, and it reads as follows. Therefore, the court holds that military use refers to weapons that are selected, procured, tested, and issued to military members for use in combat. With this in mind, none of the weapons, magazines, or attachments prohibited by PICA can be called military grade since they were not issued to the military for use in combat. But what about dual-use weapons? That's right, yeah, apparently we're going to have to define dual-use weapons, weapons that can be used by civilians and which could also be used in military applications. Judgement Glen has ruled The court holds that a dual use refers to a weapon that, while predominantly useful in military contexts, are also useful for civilian offensive or defensive use in confrontation such as they would be covered by the Second Amendment's guarantee. Okay, and then finally, and what I love about a court when you have to just slug on through 168 pages is you finally get to the punchline, which starts at about page 167, but it's where the trial court decides to, give them a little side shot. So how does Judgement Glen conclude this? As follows. Sadly, there are those who seek to usher in a sort of post-Constitution era where citizens' individual rights are only as important as they are convenient to a ruling class. Seeking ancient laws that may partner well with a present-day infringement on a right proclaimed in the Bill of Rights without reading it in conjunction with the aforementioned history is nonsense. The Statute of Northampton cannot in the least bit be used to vex the rights of Illinois citizens in the 21st century to keep and bear arms. The oft-quoted phrase that no right is absolute does not mean that fundamental rights precariously subsist subject to the whims, caprice, or appetite of government officials or judges. I do like that, and for that reason, the court's ruling is... Most importantly, considering all of the evidence presented, the court holds that provisions of PICA criminalizing the knowing possession of specific semi-automatic rifles, shotguns, magazines, and the attachments are unconstitutional under the Second Amendment to the United States Constitution as applied to the states by the 14th Amendment. Therefore, the plaintiff's request for a permanent injunction is granted, and the state of Illinois is hereby enjoined from enforcement of PICA's criminal penalties. Okay, hallelujah. Let's go out and buy ourselves an assault weapon in Illinois right now. Nope, you can't. You can't. And this is where I got to do the buzzkill now, Illinois, because Judgement Glen then just put a 30-day stay. As we know, the state of Illinois has already filed an appeal. The Seventh Circuit is going to suck this up like a bad Hoover vacuum cleaner, and away we go. And again, I will give you our 4-word prediction, which is win, stay, appeal, lose. We're halfway home already. Listen, we're going to go ahead and link up the court's order down below so you can actually geek out on it for yourself. Set aside some time. It is 168 pages. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video, you click on that link right there. You let us know. If you want to subscribe to our monthly newsletter, all of that information is right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.